This case considered the issue of the mortgagee's power of sale, and whether or not a mortgagee could sell a mortgaged property to a company of which he was a shareholder. In this case, two men were mortgagees, and they exercised their rights of sale over a property. They placed advertisements to sell the property. However, when it seemed that a sale would be unsuccessful, one of the men, who was a solicitor, suggested to an accountant that a company be formed to buy the property. The accountant agreed to form this company and purchase the property, and the solicitor became a shareholder in the company. Sometime later, the original owners of the property brought an action against the mortgagee, seeking to have this sale of the property set aside, on the basis that the sale was fraudulent, undervalued, and that the purchaser was one of the mortgagees with an interest in the company. The mortgagees argued that the property was speculative in nature, and that this was necessary to achieve the best price. He argued that such a transaction was against public policy and ought to be set aside on grounds of equity, and that the mortgagee breached their fiduciary duty to the mortgagor. The mortgagee, however, argued that he did not sell the property to himself. The central issue for the court, therefore, was whether or not the mortgagee's sale should be set aside. The court ultimately held that the transaction